In 1877, Arthur Houldsworth paid £9,000 for shares in the City of Glasgow Bank on the strength of representations made to him by the manager and the directors of the bank, presumably representations to the effect that the bank's position was healthy. In 1878, the bank went into liquidation with heavy outstanding financial obligations. As a shareholder without limited liability, Houldsworth was required to pay calls on his shareholding. These amounts far outstripped the £9,000 of his initial investment. When he sued, he had already paid £20,000 in calls and anticipated a further £200,000. A person who makes a purchase on the basis of fraudulent misrepresentation usually has two options. They can retain their purchase and seek damages, or they can rescind the contract, in which case they give back their purchase and the full purchase price is returned to them. In this case, rescission was impossible because by the time Houldsworth sued, the bank was in liquidation. So the question before the court was whether he, as a shareholder of the company, could sue that company for damages whilst remaining a member of the company. The court said this was not possible. Earl Cairns said, "We are accustomed to use language as to such a sale and purchase as if the thing bought or sold were goods or chattels, but this it certainly is not. The contract which is made is a contract by which the person called the buyer agrees to enter into a partnership already formed and going, taking his share of past liabilities and his chance of future profits or losses. He has not bought any chattel or piece of property for himself. He has merged himself in a society." The principle which emerged from this case was that the purchase of shares is different from the purchase of a chattel, and a person who is induced by fraudulent misrepresentation to become part of a corporation cannot then sue for damages the corporation which they're now a part of. Their only option is to rescind the contract, and if this cannot be done, they have no options at all. Houldsworth was therefore left without a remedy. Nowadays, whilst it's still important to know that this rule once existed, Section 247(e) of the Corporations Act has overturned the rule in Houldsworth. It is now possible to seek damages after obtaining a shareholding which was induced by fraudulent misrepresentation.